Miss Adams, I need, who did you say was in person?
Mr. Gibson.
Oh, yeah. All right, Miss Adams, if I could get James Goff and Louis Mota from the jail.
Okay.
Good morning, Your Honor.
Good morning. So we'll see who we get first. I'm gonna take my jail ones first. I'll be right back.
All rise.
You can be seated. So I have a couple small sentencings, so I'm gonna do those first before we start. Where is Miss Lenigan? Mr. Bennett, Mr. Mota, is he in custody? I think he is.
Yes, Your Honor. Yes, he is.
all I got is what they got. Middle clerk.
Hi, this is Judge Anzalone. I'm gonna need Mr. Goff and/or Mr. Moda start out with, and then Mr. Late and Miss Barrage.
Okay, so Goff, Moda, Lake, and Barrage.
Yes.
Okay, I will let them know.
All right, thank you.
Thank
Bye.
you. Bye.
Good morning. Who do I have joining me from the jail?
Goff, Jim Goff, G-O-F-F.
I just say it on the record. So. Miss Adams, could you come here for just a moment?
Judge, she's on the phone. She'll be in just a moment.
Going off, like, is that off? I don't know.
Well, I'm gonna. I think he's down there. Right. Oh my God. I'll work with pretty easy. All right, thank you.
All right, Mr. Noe, I apologize. My file wouldn't open, so I appreciate you sending us yours.
My pleasure. And Miss Blanchard didn't have one either. I just sent one to her too. I think it's one of those ones now that we're sentencing people to misdemeanors in certain court, sometimes wires just get crossed sometimes.
Yeah, no, it's all right. Thank you.
My pleasure.
Okay, this is in the matter of people of the state of Michigan versus James Henry Goff, file number 2023-213-65FH. I have Charles Noe appearing on behalf of Mr. Goff, and I have Amanda Wagner appearing on behalf of the people. It's my understanding that we do have someone appearing in person today to speak. Is that correct, Ms. Wagner?
Your Honor, I thought we did, but I don't believe that she's appeared unless Ms. Petty is telling you otherwise.
She is saying no, she has not appeared, and she is not in my waiting room. So, Mr. Goff, have you had an opportunity to read and review the pre-sentence report?
Yes.
Okay, have you had an opportunity to speak to your attorney about it?
Yes.
Are you satisfied with Mr. Noe as your attorney and the advice that he has given you?
Yes.
All right. Mr. Noe, do you wish to explain or challenge the accuracy or relevancy of any information in the pre-sentence report?
Judge, I know it's one very small thing, but actually Mr. McCarron emailed me about this. And I don't think it really matters. He was a district court judge on the preliminary exam. It says the judge is Morgan on there. Again, it's just Mr. McCarron even emailed me about that. It was just his typo. Again, it's just one of those things. Is that really accuracy, relevancy? Probably not. But it's just one correction that needs to be made on the record for the PSI, just to dot our I's and cross our T's, Judge.
Okay, so it was Judge
Morgan, who was the district court judge for the preliminary exam. Again, I don't think it really matters necessarily, but nonetheless, you asked, Judge, so you got my answer.
Does the pre-sentence report disclose any prior convictions in which there exists any known constitutional defect?
None, Your Honor.
Before the court passes sentence, is there anything you'd like to say on behalf of Mr. Goff?
Briefly, Your Honor, Judge, my client understands the seriousness of this incident. He's sitting in jail. He's actually been in jail. I confirmed with the court. I'm sorry, with the jail, and also I checked on Vine it puts his booking date was July 20th of 2023. So he has been in jail for several months now. In terms of the to the month, 3 months. No. Yeah, 3 months he's done, and ultimately, there's a PPO violation in this matter that he also had some time for. In addition to that, he's in jail till February on a probation violation from this incident. In addition to that, this court is well aware Mr. and Mrs. Goff are divorced now. Ultimately, they realize that they can't be together. They shouldn't be together. that this is something that was, I guess, toxic is maybe the best word I can use, the two of them together. So, ultimately, though, Judge, to long and short of the sentencing today, I've reviewed the pre-sentence report. I certainly have reviewed, most importantly, the recommendation for 93 days in Lenawee County Jail. We would ask for my client to be sentenced to 93 days in Lenawee County Jail. Time served, my client has indicated to me, and I'll further reiterate the record, that my client does not obviously wish to do a term of probation. And ultimately, reviewing the time he's been in jail, I don't think that'd be an option. I think he'd be maxed out at this point. So he's not going anywhere. He's there to the best of my knowledge. Outdate, I think it's February 21st, according to Vine, but that could be wrong. I see Mr. McGough nodding his head. So February 21st is the earliest release date. So ultimately, Judge, we would be asking you to sentence with the recommendation 93 days time served, and close out this matter that has been that's been tumultuous, to tell you the truth. Obviously from Mrs. Goff as well, most importantly. So we would ask you to follow the recommendation and sentence my client accordingly. Thank you, Your Honor.
All right, thank you, Mr. And I'll give you an opportunity, Ms. Wagner, but Mr. Goff, is there anything you'd like to say on your own behalf?
No, Judge, to you, I say thanks for your kindness and professionalism, and I just want to get on with my life, Judge, and pre-2022, back to a normal existence. So thank you very much.
Thank you. Ms. Wagner, anything on behalf of the people?
Thank you, Your Honor. As of yesterday, we did anticipate that Ms. Goff was going to be here this morning, either in person or on Zoom, to give a statement. Obviously, she's not here. And really that's why I'm here, Your Honor, is because I thought that she was going to be here. I will just point out, I understand that the court is limited in what it can do today, but I think it's important just to note that even according to the PSI, Mr. Goff has a lengthy assaultive history, much of which is with this particular victim, Jeannie Golf. He has violated district court probation multiple times. He violated the PPO with the same victim, and you heard that, Your Honor, and you threatened to max him out on jail if he violated it again. I continue to receive information that Mr. Goff is still communicating with her to this day. However, Ms. Goff is not here to make that statement. I can only sincerely hope that Mr. Goff has learned something out of all of this, and that he will stop communicating with her, and that this cycle of assaultive behavior will stop. And that is my sincere hope.
Thank you. Well, in determining the appropriate sentence in this case, the court has considered the seriousness of the offense, your history, the principle of proportionality, the statutory penalty, the cost of confinement, the sentencing guidelines, the report and recommendation of the probation department, as well as what has been said upon the record at this hearing. The criteria and reasons for the sentence are the nature and gravity of the offense, the discipline appropriate to its commission, deterrence against repetition by you and by others, potential for reformation, vindication for law and protection of society. Mr. Goff, you had pled to a 93-day misdemeanor, and as of today's date, you have about 93 days credit. So the court is limited in terms of what I can do, and you are asking to be maxed out. And so at this point, it is the order of the court that you will serve 93 days in jail. We'll give credit for 93 days already served. Now you do have the right to appeal this sentence. We will send over to the jail 3 copies of your notice of right to appellate review. You need to initial and date 1 copy. That'll come back to me to go on the file, just to acknowledge you received your appellate paperwork. If you wish to appeal the sentence, you would fill out the information on the form and mail it to the address listed on the form within 42 days. All right?
Yes, Judge.
All right. So you're all set, Mr. Goff. Could you let them know I need Mr. Mota next?
Molten?
Mota, M-O-T-A, Mota.
Okay, Judge, thanks.
Thank you. Thank you, Mr. Noe.
Thank you, Your Honor. Have a good rest of your day. I'll see you in person in about an hour, Judge.
Okay.
Yes, thank you.
Mr. Malta?
Yep. Yeah, got one more back here.
Ms. Bregman and Ms. Hennigan, while I'm waiting, you guys want to step up real quick? Out, not out. That's fine. I just wanted to make sure that everybody was okay with their.
Wheel that right out, wheelbarrow.
Yeah.
Right in here.
Yes. Thank you. All right, Mr. Bennett. All right, Mr. Moda, can you hear me?
Yes.
Good. All right, this is in the matter of the people of the state of Michigan versus Louis Martin Mota, file number 23-21303FH and 23-21304FH. I have Samuel Bennett appearing on behalf of Mr. Mota, and I have Allison Arnold appearing on behalf of the people. This is the date and time set for sentencing on both of these files. Mr. Moore, you're stepping in for Mr. Jones today.
Yes, Your Honor.
All right. So, Mr. Mota, have you had an opportunity to read and review the pre-sentence report?
Yes, Your Honor.
Okay. I have a first student bus driver in my waiting room, Timothy Jordan. Anybody know what that is? Okay. Anyway, all right, not on this case then. So have you had an opportunity then to discuss the pre-sentence report with your attorney?
Yes, Your Honor.
Are you satisfied with Mr. Bennett as your attorney and the advice that he has given you?
Yes, Your Honor.
All right, Mr. Bennett, do you wish to explain or challenge the accuracy or relevancy of any information in the pre-sentence report?
No, Your Honor, the report is factually accurate. It's more of an update report, given that Mr. Mota was on probation earlier anyway. Miss Arnold and I do have a stipulation to OV4 for the guidelines. That should be scored at 10 points. It doesn't change the guidelines, but it should be scored at 10.
So OV4 will be scored at 10 points. Mr. Moore, I could just make that modification on the guidelines that I have.
Okay, yep, thank you.
You're welcome. All right, very good. Does the pre-sentence report disclose any prior convictions, Mr. Bennett, in which there exists any known constitutional defect?
No, Your Honor.
And Mr. Mota, all your background information was correct in the report?
Yes, Your Honor.
All right. So if we make that change to offense variable number 4 to 10, the total OVs will be 45, and that will make the sentencing guidelines 43 to 86 months still. Do you agree with that calculation of guidelines, Mr. Bennett?
Yes, I do, Your Honor.
And Ms. Arnold?
I do, Your Honor.
All right. So, Mr. Bennett, before the court passes sentence, is there anything you'd like to say on behalf of Mr. Mota?
The only thing I'd like to say, Your Honor, is I've gotten to know Louis really, really well over the last year and a half or so. He's taken responsibility for his actions, and I ask that you follow the plea and sentence agreement and the recommendation, which places him in MDOC for 5 to 15 years with 408 days credit, Your Honor.
All right, Mr. Mota, anything you'd like to say on behalf of yourself?
No, Your Honor.
Ms. Arnold, anything on behalf of people?
Judges, the court knows Mr. Mota committed these 2 offenses when he was on probation for criminal sexual conduct, 2nd degree. He is charged with the 2nd offense notice. He's scarred an additional 2 victims, and we believe the recommendation is fair and would ask the court to follow it.
Mr. Moore, to your knowledge, any additions or corrections at this point to the PSI?
No, Your Honor.
In determining the appropriate sentence in this case, the court has considered the seriousness of the offense, your history, the principle of proportionality, the statutory penalty, the cost of confinement, the sentencing guidelines, the report and recommendation of the probation department, as well as what has been set upon the record at this hearing. The criteria and reasons for the sentence are the nature and gravity of the offenses, the discipline appropriate to its commission, deterrence against repetition by you and by others. Hold on. I just was handed from Ms. Petty from the prosecutor's office an impact statement from a Michael Martin. I'm going to assume Mr. Bennett has not received that.
I have not, no, Your Honor.
Okay.
It
And
wasn't in
Ms.
the
Arnold?
PSI.
I do not have it. We can have that emailed to the court and Mr. Bennett. I mean, I can email it to Mr. Bennett if we can, if the court can give me just a minute.
So I've been able to read it, and I do believe the concerns that were voiced were taken into account with the plea agreement. So it would not alter the sentence in this court.
Thank you, Your Honor. And Your Honor, I have no objection to proceeding with sentencing. I'll have Ms. Arnold send me that and I'll keep it for my file.
Is that all right, Ms. Arnold?
Yes, thanks, Judge.
Great. The criteria and reasons for the sentence are the nature and gravity of the offenses, the discipline appropriate to its commission, deterrence against repetition by you and by others, the potential for reformation, vindication for law, and the protection of society. On file number 23-21303FH, it is the sentence of the court that you will serve a period of 5 years to 15 years with the Michigan Department of Corrections. I will give you credit for 408 days served. You are to pay $130 crime victim rights fee, $68 in state costs, $60 DNA fee if applicable, because I realize you're on probation. You are to have no contact with the victim with the initials AA, and you are to have no contact with minors age 16 or younger. You are to remain active on the sex offender registry for life. On file number 23-21304FH, the sentence of the court that you will serve a period of 5 years to 15 years with the Michigan Department of Corrections. We will give you credit for time served of 408 days. You are to pay $130 crime victim rights fee, $68 in state costs. You are to have no contact with the victim on that file with the initials of the LM. You are to have no contact with minors age 16 years or younger. You are to remain active on the sex offender registry for life. And those sentences would run concurrent. Now, you do have the right to appeal this sentence. Mr. Moore, anything I should add?
No, Your Honor, just after this to address the other case. The probation.
The probation violation?
Yeah, yes, I think
He
we're
was-
going to discharge.
Yeah, he's supposed to be unsuccessfully discharged on that offense.
Okay, all right, and
I
then
believe that was already done by Mr. Jones.
I think he's already been discharged. I don't have the
I
file
have-
and I don't have the paperwork.
Yeah, I have the paperwork in front of me to send over to you. I didn't know if you were addressing it first in court, but I'll send
I
it.
wasn't, but what's the file number, Mr. Moore?
It is 20-19945-FH.
So on that file, the agent has prepared the discharge paperwork, and that'll come over to my office right now, and I will sign that, and he will be discharged from probation on that file.
Thank you.
So Mr. Mota, you do have the right to appeal this sentence. We're going to send over to the jail on each file 3 copies of your notice of right to appellate review. I would ask that you initial and date 1 copy for each file for our records that would acknowledge your receipt of the paperwork. If you wish to appeal your sentence, you would fill out the information on the forms and mail them to the address listed on the form within 42 days. Anything else, Mr. Bennett?
Nothing more for me, Your Honor. Thank you.
Ms. Arnold?
No, thank you, Your Honor.
All right, very good. Thank you, Mr. Mota.
Thanks, Your Honor.
Thank you. Good luck, Mr. Mota. Give me a call or send me an email when you get a chance, okay?
Okay, thank you.
Mr. Mota,
Take care.
could
You're
you
welcome.
Yes,
let
Your
them
Honor.
know I'd like to see Mr. Late next, LAPE, late?
Yes, Your Honor.
Thank you.
Mhm.
Right, Miss Mead and Mr. Jordan, you are here on Stephanie Finley behalf, correct?
Correct. I'm standing in for Mr. Keith, who's preoccupied with a first child.
Well, good for him. So in the matter of Stephanie, Miss Adams, could I have the Finley progressive file? I thought I would,
Of
know,
course.
sentencing, so I didn't bring it in. All right, so in the matter of Stephanie Ann Finley versus Progressive Michigan Insurance Company, First Student Inc. and John Edward Tadaro, file number 2022-226957 and I. So I have and Melissa Mead, P 75730, appearing on behalf of defendant Progressive. And then I have Timothy Jordan appearing on behalf of defendant Tadaro, correct?
Correct. And student first or first student, depending on.
But I do not have an attorney here for the plaintiff yet. So we'll just wait a minute on that, okay?
Certainly. Thank you.
All right, Miss Underwood, I do have Mr. Late. So are you ready to proceed?
I'm sorry,
Are you ready to proceed?
we are ready to proceed, Your Honor.
All right, so if you want to step up to the podium and adjust your microphone. So this is in the matter of the people of the state of Michigan versus Christopher David Late. We have 2 files, 2022-20901FH and 2023-21489FH. We have a probation violation sentencing on file number 2022-20901FH and an initial sentencing on the other file. Ms. Underwood, have you had an opportunity to meet with your client?
I have, Your Honor.
All right, so Mr. Lake, you have had an opportunity to read and review both the probation violation report and the pre-sentence report?
Yes, Your Honor.
All right, and have you had an opportunity then to discuss those with your attorney?
Yes, Your Honor.
Are you satisfied with Ms. Underwood as your attorney and the advice that she's given you?
Yes, Your Honor.
Ms. Underwood, do you wish to explain or challenge the accuracy or relevancy of any information in the pre-sentence
I
report?
don't believe we do. We just want to make sure that Mr. Leif's I believe thought he might have a couple extra days of credit. Is that correct, Mr. Lake?
Yes, Your Honor, or yes, Ms. Underwood.
We show you were arrested on June 13 of 23. Is that correct?
I was arrested on June 4th.
That was the violation. He was arrested for the violation on June 4.
So he was arrested on the violation of probation on June 4, and he wasn't arraigned on the new file and taken in or arrested per se until June 13.
Okay,
All right, so do you understand, Mr. Lee?
there's the
that
explanation, Mr. Lake. But you were correct. You were in jail on the 4th.
You get credit from the 4th on your violation of probation. Do you understand that?
Yes, Your Honor.
Okay. So, Ms. Underwood, do you wish to explain or challenge any other information in the pre-sentence report and the probation violation report?
I don't believe so, Your Honor.
Does the pre-sentence report disclose any prior convictions in which there exists any known constitutional defect?
It does not.
All right, so on, let's see, on the new file 23 let's see, 21489FH, the probation department has calculated the minimum sentencing guidelines to be 12 to 24 months. And let me see, is there another one? Yep, so I'm getting used to the new reports. So on the police officer fleeing and eluding, second degree, the probation department calculated the minimum sentencing guidelines to be 29 to 57 months. On the firearms possession by a felon, the guidelines were calculated to be 12 to 24 months. And on the ammunition possession by a felon, the guidelines were calculated to be 12 to 24 months. Do you agree with that calculation of guidelines?
We don't wish to contest the
Okay.
guideline calculation, Your
All
Honor.
right. Before the court passes sentence on both files, is there anything you'd like to say on behalf of Mr. Lake?
A number of things, Your Honor. First, Your Honor, I have been very impressed with the fact that Mr. Lake, from the moment he talked to the officers, Your Honor, accepted responsibilities for these actions. I don't think we'd be here today, honestly, if he hadn't. Mr. Lake has had a great deal of time in jail to think about his actions in this matter, Your Honor, and he realizes how he screwed up. I think that Mr. Lake sometimes, and a lot of times, is his own worst enemy. I do think he has, and he will agree, that substance abuse plays a part in this. I think it definitely does. I think Mr. Lake has the support of his family. His mother is here today. Natalie is here today. And they love Mr. Lake very much and want him to succeed. Your Honor, when we did the calculation, we thought the guidelines would be around 34. They turned out to be 29. And Mr. Lake very much wants the opportunity to do boot camp if the MDOC feels he's qualified when he gets there, Your Honor. We would ask the court to sentence Mr. Lake to the low end of the guidelines on this matter, Your Honor, and run these sentences concurrent and give, I don't believe Mr. Lake has been to prison before, Your Honor. This is a long first day. So we would ask the court to consider the low end of the guidelines, Your Honor, and a signature for boot camp if the MDOC sends a request. Thank you very much.
Thank you. Mr. Lake, anything you'd like to say on behalf of yourself?
That I'm sorry for my actions. I do take responsibility for it, like Miss Underwood said. And I regret my actions.
Mr. Moore or Ms. Teskey or Ms. Holly, one of you can probably answer that. The recommendation is for 36 months. 3 to 10, so 36 months would not preclude him from boot camp.
No,
Anything over that would.
right.
But there was an agreement to 34, Your Honor.
Right, I was just checking on the boot camp. Okay. All right. In determining the appropriate sentence in this case, the court has considered the seriousness of the offense, your history, the principle of proportionality, the statutory penalty, the cost of confinement, sentencing guidelines, the report and recommendation of the probation department, as well as what has been said upon the record at this hearing. The criteria and reasons for the sentence are the nature and gravity of the offenses, the discipline appropriate to its commission, deterrence against repetition by you and by others, the potential for reformation, vindication for the law, and the protection of society. On file number 22-20901FH on the violation of probation file. Restitution. This sentence of the court that you will serve 1 year, 11 months to 60 months with the Michigan Department of Corrections. That would be concurrent to the other sentence. I will give you credit for 198 days already served. On file number 23-21489FH, it is the sentence of the court that on count 1, 2, count 3. All right, so hold on one second, make sure. Okay, on count 1 through 3. 1, count 2, count 3. All right, so it is the sentence of the court that on count 1, police officer fleeing 2nd degree, you will serve 34 months to 10 years with the Michigan Department of Corrections. On count 2, which would be the firearms possession of a felon by a felon, you will serve 24 months to 5 years with the Michigan Department of Corrections. And on count 3, possession of ammunition by a felon, you will serve 24 months to 5 years with the Michigan Department of Corrections. These counts will serve concurrent to each other, as well as concurrent to your violation of probation sentence. You will receive credit for 129 days already served. Well, obviously, I have no authority over whether or not he's approved or they submit anything for boot camp, but I usually have no objection to anyone going to boot camp because I think it's a great program. So if it comes through that you're approved, Mr. Leif, I would sign that. While under MDOC, you will comply and complete all programming recommended, including your GED, substance abuse, alcohol abuse, job skills training, impulse control, any restructuring, parenting skills, and domestic violence training they recommend. There is a crime victim assessment fee in the amount of $130 on count 1. On count 2, no, I'm sorry. Is that just on one count?
Yeah.
Yeah, and then there is a $68 state cost on each count, equaling $204. And then upon release for parole, there is a supervision fee. As a condition of parole, you are not to reside at 8640 Pentecost Highway in Onstead, Michigan. Anything I'm missing, Miss?
I don't think so.
All right, so, Mr. Lake, you do have the right to appeal this sentence. So for both files, you're going to receive a notice of appellate rights. You're going to initial and date the top copy. That's going to come back to me for my file. The other copies are for you. If you wish to appeal your sentence, you would fill out the information on the form and mail it to the address listed on the form within 42 days. All right? Anything else, Ms. Holly?
I don't think so.
Ms. Underwood?
No.
All right, good luck to you, Mr. Lake.
Good luck, Mr. Lake.
Thank you.
All right, Mr. Lake, can you tell the jail I don't need anybody else right now?
Yes, Your Honor.
Thank you. Let me get rid of the jail window.
Judge, are you not doing Colleen Barrage today?
Is Michael Dagger Margosian his attorney, her attorney?
Yes.
I don't have Michael Dagger Margosian,
Okay.
so I got another sentencing to do. All right, so. All right, so I now have. Let me see. Mathis, Melissa Mead. So Brooke Mathis, you're here on behalf of Stephanie Finley, correct?
That is correct, Your Honor.
All right, so this is daytime, except for what? A status conference. So I thought it would be, yep. I can't find it. So this is date and time set for a settlement conference in this matter. I do have another sentencing that's going to take a little bit of time to do. So. Jury demand. All right, so you dismissed jury demand back on September 14th. All right, so I guess all right, counsel, where do we stand at this time on this file?
Your Honor, we recently amended our complaint to add first student as a defendant. They just filed their answer back on the 2 days ago, actually, that we received it. We are in the discovery phase of litigation right now, and things are going well. We've exchanged discovery with the prior party that was in it. We're sending out discovery to first student this week.
Come on, Barry.
So do you want me, all right, so we have a couple options today. We can, let me get rid of the jail room, it's keeping back noise. We have a couple options today. I can give you another status conference just so that everybody can get up to speed because we have a new appearance. And then when we come back at that time, we can set dates, or I can set discovery dates today.
I would be fine with the first option, Your Honor, of coming back after the parties get situated.
Mr. Jordan?
It makes sense because we need a few months to look into IMEs or depositions of dentists and other things. So if the court wants to set a status conference for maybe 60 days or whatever the court's preference, and then set dates after that, should be in a much better position to advise the court.
All right, Ms. Mead?
Yeah, I have no objection to that either, Your Honor.
Ms. Adams, I'm looking for a settlement conference date, minimum of 60 days out, but I realize that will take us right to Christmas. So I'm fine with like January 5th or 12th.
Okay.
And Your Honor, would that be settlement or status? You said
Call it
settlement. So I get nervous when I hear settlement all of a sudden. Just want to make sure.
Well, I'm looking for a blue sheet in this file, and for some reason I'm not seeing it. So, Ms. Mathis, we've not set discovery dates or anything on this file, have we not?
No, we have not, Your Honor.
So I could do a pre-trial date on a Monday afternoon, so we could set those dates.
Okay.
Why don't we do that, Ms. Adams, Monday afternoon?
Okay.
We could do December 18th at 1:30.
That works for
Okay.
us.
Mr. Jordan?
It should work, Your Honor, yes.
And what about you, Ms. Mead?
Would that just be to set dates? Because if so, I can have someone cover for me, no big deal.
Yeah, it would just be Zoom and setting discovery dates.
Perfect, then that will work.
All right, So I filled out a scheduling order. I will mail it out to everybody, not me, but my staff will. And we'll see you back on that day. Good luck.
And it was the
Thank you.
18th at what time, Your Honor?
1:30. You
1:30,
said
thank you.
1:30, Ms. Adams?
Yeah, that's correct.
Perfect. Thank you, Your Honor. Just want to double check.
All right,
Thank you,
thank
everybody.
you.
Take care.
All right. All right. This is in the matter of the people of the state of Michigan versus Justin James Gibson, file number 2000-9028 FC. I have Jennifer Bruggeman appearing on behalf of Ottawa County Prosecutor's Office, and I have Tamaris Hennigan appearing on behalf of Mr. Gibson. This is the date and time scheduled for a resentencing under some recent changes in the law. And I want to commend both counsel for very in-depth briefs and responses, and I appreciate that. So, Ms. Hennigan, are you ready to proceed?
We are, Your Honor.
All right. And Ms. Hennigan, I did not receive where they updated the entire pre-sentence report, but I did receive a pre-sentence case report updating the information. Did you receive that?
I did, Your Honor.
Have you received everything you need to proceed today?
I have been.
Ms. Bruggeman, have you as well?
Yes, ma'am.
All right. And so it's not a typical sentence because I assume there's going to be argument on the information contained in the briefs, correct?
Yes, ma'am.
All right. So Ms. Hennigan, before we, before we proceed, do you want to address your brief and what you want the court to consider today?
Yes, Your Honor, thank you. Trying to find average height.
It was Rhonda.
But, Your Honor, I'm going to be very brief in addressing the objections that we made to the pre-sentence report and the recent objections that we made. They're based from our position solely on what we believe that the Miller factors require to be considered. And so in going through the one-page pre-sentence case report that we received, the updated or revised one, we felt that they used, the state used the abbreviated Miller factors, while the actual Miller factors do go into more depth and require that more things be considered. So we know that this court reads our documents. We know that this court has reviewed those documents. And I'm not going to belabor that with going through all of those, just acknowledging that there were errors as to Justin's age at the time of the crime. He was 15 and not 16. And we do feel that that is the only thing that was addressed with regard to his age and immaturity, impetuousness, et cetera, that are required by Miller. And we thoroughly laid out our position on that. We also noted that they abbreviated factors. They used factors 3 and 4, whereas those should be just factor 3. And so we've combined those together and responded to any inaccuracies that were there. A very important note to us is that it was noted that Justin was never abused in his home. And since the time of this crime, as I noted, that was 23 years ago. People didn't talk about the abuse in their home 23 years ago, but since that time, Justin and his mother, his siblings have all come forward and they've had time to heal, time to go to counseling, and they speak very freely about the abuse that did occur in that home. And had any of them been reached out to, it's certain that they would have shared that information with MDOC as well. But you saw that there were letters of support there stating what they felt about the abuse that took place in the home back then and how that impacted Justin's life and their lives. In addition, we did not note that the pre-sentence case report addressed factors 4 and 5 at all of the Miller factors, one of those being simply whether or not had Justin been an adult and been more mature, could he have helped with maybe negotiating a lesser charge or a lesser sentence? They didn't address that, but we do not assert to this court that that would have changed anything in Justin's particular case. And then factor 5 being that the possibility of rehabilitation, and that was not addressed either. And so we have put in our objection and Justin's response that it's our position that not only is there a possibility for Justin to be rehabilitated, but that Justin has demonstrated that he has been rehabilitated for the things that he has done, not only taking advantage of everything that's been available to him as a lifer, but also helping to create new programming and seeing the deficiencies in the MDOC's current program and what life has had available. Justin has taken the initiative to help create new programming and continues to facilitate that, which has allowed him over his years there to continue to demonstrate his ability to be rehabilitated and how much he has actually succeeded with his rehabilitation. So I think that that's the main basis. And again, we would rely upon our brief that we've submitted. Thank you.
All right, and did you want to ask for response?
I do, Your Honor. A couple things. With regard to the objections that were just filed this week on the updated PSI. Well, one, I would agree that the age needs to be changed to 15. At the time that he was sentenced, he was 16. By the time of the offense, he was 15. So that does need to be changed. Also, the beginning sentence, 2 sentences in the updated case report, that's inaccurate. That needs to be removed. Those bills have to do with outlawing life without parole in general. Those are being proposed. That has nothing to do with this case. This case came back to the court, as it knows, because of people of East Stovall, and that Mr. Gibson was convicted of second-degree murder and given life with the possibility of parole, which has been determined to be unconstitutional. So this court is directed to give a term of year sentence. I'm not going to belabor all of that, but again, those 2 sentences in the beginning need to be removed. The only other thing I would say with regard to the updated report and the objections, a couple things. The probation officer's duty under the law is captured in MCL 771.14 and the court rule 6.425. I know that the court asked probation to address the Miller factors, but really the ultimate issue is whether the information is getting before the court. That's what the case law says. So Ms. Hennigan has done that. She has supplemented anything that they believe needs to be addressed to the court, given the information with regard to his institutional record, his rehabilitation as they see it. All those Miller factors have been addressed in one way, shape, or form, either through myself, through Ms. Hennigan, through the probation court, or through probation. So as far as the content of it, an updated PSI, really the obligation there is to just make sure that the information is presented to you. So I don't believe that we need to belabor that point as far as what probation is required and not required to do. And so with those corrections, the only other thing I would address would be the comment in the report that says he was not abused in the home. I could be wrong, but I believe that probably was referencing the grandparents' home.
Yes.
That's how I interpreted it. And there really is no evidence that I've seen that Mr. Gibson was abused in the grandparents' home by the grandparents. Now, if we want to add in that word grandparents' home, I don't know if defense would agree with that or if they still have other objection to that, but that's how I reviewed it. I do think that there is information in the record that does support that there was some mental and physical abuse by his stepfather, maybe also his father. But again, I think that that's in the record. So I believe that's what I saw as far as any kind of quote unquote inaccuracies. The only other thing I would say with regard to like the brief that was, or the objections that was filed, there continues to be a claim about, or not a claim, but there's a difference in story with regard to the offense itself and the facts behind it. And all I would note is that I realize what Mr. Gibson is saying now or has said in certain instances, but the agent's description of the offense and at the time of the original sentencing was never objected to, was never raised on appeal. There was no issue with that. And so I would ask this court to consider that as far as from the standpoint of in evaluating Mr. Gibson's accountability and the remorse that he shows for what happened in this instance. I think I pretty much laid out, I had a lot to say, but at the same time, I think it is all laid out in my original sentencing memorandum. I didn't respond to this one time-wise. I didn't have time to. Really, I think as far as the Snow and the Miller factors that this court needs to consider along with Mr. Gibson's youth, the court is required to take all those things into consideration and is required, which this just was clarified in a case that came down the other day, is required to account for his youth as a mitigating factor. That's not an option of the court. So and even though the case law is kind of all over the place as far as what the court's obligation is, as far as stating on the record how the court considered it, I would ask this court to address that to the extent they can to avoid any future issues about appeal-wise and what have you, because it is a new thing. Obviously, this court has never done this before, and it's new in general in the state of Michigan. So I get the difficulty here. One, we're 20-some years from the original offense. It's difficult to do. It's like looking hindsight at things. And so lastly,
Ms. Berman, you said a case just came down?
Yeah, so it was Boykin, which actually
not just like this week came down.
no, but Boykin, so that came down a while ago, but at the same time, it's been going all over the place.
Right, it's 510-171.
Yeah.
It's in your brief, so
Okay.
I thought you meant there was like a new one.
No, although I'm trying to find where I had it.
On page 4.
No, I just, give me one moment, Your Honor. Okay, so, yes, I think where I was, why I wanted to mention it again was because there was a case, and I think it was an unpublished case that just came down that really hammered that the defendant's youth must be treated as a mitigating factor, not just whether the defendant's age was a mitigating factor. And it seems like such a fine line, and I think that's what the court was saying, but really this court must, and so view it as a mitigating factor. And so I just wanted to note that. But lastly, I would just say, I know that the sentencing guidelines calculate it 270 to 450. There has been no objection to those, either at original sentencing or now. The proposed sentence from probation is 450 to 900. Mr. Gibson has served 279 months and some change. And they're asking for a downward deviation, claiming that he is rehabilitated. I wholeheartedly disagree with that. I believe that one, Mr. Gibson needs to be supervised. He needs to be on parole at some point. I don't think he's shown through his misconducts in prison, which the last one was in 2022, which is somewhat concerning because this has been going on before 2022 as far as coming back to court on this. So that's concerning from an alcohol standpoint. The fact that he had a misconduct for dangerous contraband. I don't know the facts of all that, but it's concerning. The other thing is Mr. Gibson, I think admittedly, has been limited in the types of programming that he's been offered because he is a lifer. So that's no fault of him, and he has taken advantage of various things. And there are a lot of people that support him, and which is great. And I'm happy about that. But we can't also forget what happened here. We have a victim. We have two, Miss Myers, obviously deceased. Mr. Myers has since passed away, and so he's not here to speak. And I don't know how he would feel today. All I know is how he felt at the original sentencing, which was not to let Mr. Gibson out ever. And I would ask the court to take that statement that I reiterated in my brief, as well as it's in the sentencing record, take that into account. The other thing I would just say is that, again, the changing statements of what happened on the date of the incident, the accountability that seems to shift depending on who he's talking to or the purpose. And so while I'm not in his mind, obviously, but his psychological evaluation, which I know he has issues with as well, but that did raise some issue with remorse and accountability. And again, I have a hard time with the changing of the story and what happened. So again, I would ask this court to, I believe it's proportional and appropriate and reasonable for the offense and the offender here to for his sentence to be, the minimum sentence to be towards the higher end of the guidelines, no less than 360 months. I don't feel he's ready and has shown to this court that he has been rehabilitated, and I would ask the court to sentence on the high end of the guidelines. Thank you.
So I just wanted to get a little bit of that argument on the record, and then I'm going to move to my normal sentencing procedure at this point. And then you'll have another opportunity to speak. And I do believe we have someone representing the victim's family as well as the same family as the defendant today. So, Mr. Gibson.
Your Honor, I'm sorry, could I just address the changes that Ms.
You will. I'll give you a chance.
Thank you.
So, Mr. Gibson, you've had an opportunity to read all the pleadings in this case.
Yes, ma'am.
You've had, wait, you guys will stand for points, we just get a better record. Because there's a microphone, so, all right, so you've had an opportunity to read all the pleadings.
Yes, ma'am.
And you've been able to meet with your attorney as needed?
Yes, ma'am.
You had an opportunity to discuss everything involved in this sentencing?
Yes, ma'am.
And you've had an opportunity to review the pre-sentence case report that was provided by Mr. Moore as an update?
Yes, ma'am.
Okay. Are you satisfied with Ms. Hennigan as your attorney and the advice that she has given you?
I am, Your Honor.
So, Ms. Hennigan, do you wish, other than what you mentioned and what Ms. Bregman mentioned, do you wish to explain or challenge the accuracy or relevancy of any information in this updated pre-sentence case report?
Your Honor, I would just, first of all, I would just thank Ms. Bergerman for being so gracious this morning as opposing counsel. We're grateful that she agrees on the age change. I have no objection to the removal of the first two sentences that she has requested the removal of. We have no objection to the court deeming the phrase "in the home" as the grandparent's home. To be honest, we hadn't thought of it in that way, but we do see Ms. Bergerman's point. And my client would state for the court that he was never abused in his grandparents' home. The only thing we would ask the court to consider is that he was only in that home for a few months before this incident, and that factor 2 state is focused on the family and home environment. So it does extend further than that, but by all means, he never intended to say that his grandparents abused him.
And
then,
Mr. Moore will make that change, adding grandparents
yes.
to before home, okay?
And then we are aware that there are some differences in the story over time. And I guess that triggered for me to say perhaps Miller factor 4 would have made a difference if Justin wasn't so young. I don't know exactly how he dealt with the police at that time, but what I can say is that when we go back years in the MDOC reports, his story's been consistent with them for years. And I would say that we made a huge effort within our objections to the court to be very transparent about the gruesomeness of this crime. And in my opinion, our position is worse than what the MDOC has stated in their story of her being shot in the back of the head. And Justin's been very transparent to me to tell me that he stood facing her when this happened. And we put that in our objections because we are in no way trying to minimize the seriousness and heinousness of the crime that occurred. And other than that, the misconduct in 2022, we did address that as well. That was alcohol related, and Justin's dealt with grief over the loss of many inmates and family members who passed away from COVID. And I don't think any of us knew how to deal with the pandemic. We've never done it before in our lives. So not an excuse, but definitely that impacted him. And just to clarify with regard to the dangerous contraband, that was what the issue was. That was a stinger that's used to heat up water. So he just wanted that to be placed on the record that that's what the dangerous contraband is. And that would be all with regard to the report.
Other than a juvenile record because of his age, he had no prior adult record. And the probation department had calculated the guidelines to be 270 to 450 months. You agree with that calculation?
Yes, Your Honor, we do.
All right. So if you could have a seat, I do believe we have someone to speak. Is there someone who's going to speak today?
I don't know. That's serious.
Okay. So are we all speaking or are we just
I'm
supporting
just
one
speaking.
speaker? Okay.
Just my mom and my sister.
Okay. So can you state your name for the record?
Betty Ellis.
And what is your relationship to Mr. Gibson?
He's my brother.
Okay. Is that his mother as well?
Yes.
Okay. And you are?
Heather Jessup,
And you're?
his oldest sister.
Got it. All right. So you have a statement you'd like to make?
Yes, I would. So we are speaking on behalf of the victims. I would like to start off by saying that what I'm about to read is not just my words. These are combined words coming from Justin's family. I will cry if you touch me. Coming from Justin's family who love and are here to support in his release. This includes my sisters, Heather Gibson and Elizabeth Doucette, who had prior obligations, so she couldn't be here today. As well as our mother, Cindy Doucette. We were asked to speak about what we lost in Grandma's death and about Justin. I would like to start off with, we feel we have lost what we feel we have lost in all of this, but I also want to say that while we have lost so much, I will speak about what we have gained because we do not dwell in loss in this family. I will start with family. We became the black sheep of the family after Justin's fatal mistake. Grandma was what I called the glue of our extended family. Growing up, we had holidays with our aunts, uncles, and cousins, and we're close, but after everything that changed. Family walked away from us. We were, in a sense, in my feelings, considered the outcasts. The sense of family in that aspect was ripped from our childhood, and that is not an easy thing to deal with. Our mom lost so much when the family members turned on us, pointed fingers, made blame where there was none to be had. When you are this young, it's difficult to comprehend and understand to have so much taken from you in an instant. We didn't just lose a grandma and an extended family that day, we also lost a brother. Justin and Heather had a special bond with everything they went through as kids. Justin and Elizabeth had a beautiful bond. He adored her. I struggled the most with Justin. We butted heads and fought often due to our personalities clashing. This is obviously not the case today. Justin and Heather's dad was an alcoholic and basically estranged in their lives. And Elizabeth and I's father was in no way a model citizen. He was a drug addict, abusive, and manipulative physically and mentally. Justin grew up with a sense of abandonment, in my opinion, with a lack of examples of what a man should grow into, and learned at a crucial age to deal with your feelings in the wrong manner. As Heather has told me, they were taught to be afraid of their feelings, and in turn, it taught them to bottle them up so when they came out, it presented in anger. None of us are excusing Justin's behavior. We are simply saying that he has been through a lot at a young age, and so have we. We grew up in a small town. When you live in a small town, everyone knows everything. The looks and the judgments and going to school with everyone treating you like you are going to go off at any moment is hard for children to face. Our mother had to be judged for what her son did when she did the best she could in the circumstances that were dealt with life. As an example, I had a teacher who thought discussing the death penalty in class was a good topic of discussion. The conversation became very heated among the kids, and I became extremely upset knowing my brother was sitting in prison and confused about whether I thought he should die. I was still angry, sad, and lost. How could I sit there and wish death upon him? But also, how could I not with everything that was taken from me? I left the room crying, and for months I was looked at strangely and treated differently because I was judged. And people were worried that maybe I would do something unfortunate in some shape or form. We, as Justin's sisters, lost family, lost friends, lost the innocence of childhood. Mom lost a mother and a son all in the same moment. We are victims of this as well as others, but we also gained from such an unfortunate life event. Mom is a wonderful mother. She would give and do anything for her children. Us girls are all successful, driven. We work hard, raise our families, and are always there for each other in times of need. We have healed, we have learned to grow into better people and focus on what matters in life. There's so much strength and unity in this family that has come out of all of this. As much as the pain was terrible, I don't feel if I had a choice, I would go back and change anything because I love my life now. I love who I've become and all my siblings. Now to speak about Justin personally. As I stated previously, he was lost for many reasons. When I think back, I remember the angry young boy who was getting in trouble but was unable to be helped. Mom did what she could with the resources she had, but like many children in this world, there weren't the right resources available to help him properly, which led to a tragic situation. I look at Justin now and I see a strong, resilient, kind man who is doing his best to make amends for what he has done. Justin could have gone to prison, distanced himself, and basically gave up, but he didn't. He took his punishment. He has helped others to the best of his ability and wants to continue to help others. He has fostered beautiful relationships with his family, old friends, and has built new relationships. A broken person doesn't do this. An unchanged person does not do this. We all understand that the purpose of this court hearing is to discuss the tragedy of him taking our grandmother's life. But it is also to focus on the fact that there is a difference between a boy and a man. We do not dwell on the past, we focus on the present and beauty. I would like to focus on everything he has managed to achieve while in prison. He has put his heart and his soul into everything he does to try and better himself and try to put his truth out there so that others do not make the same mistake. He has gone through every program that he was allowed to in order to heal. That is not something a person does if there is not true growth and remorse for past action. He pours his soul into his art and writings, into programs he has worked in, which include rehabilitating dogs and helping other inmates if he can. He calls us to learn about us and what is going on in our lives, his nieces and nephews, and to be as involved as he can. I went through a very ugly divorce with my oldest daughter's dad, and that was such a hard time in my life. I can honestly say that I looked forward to his phone calls because he helped me. He helped me process my feelings, support my decisions, and was simply there for me. There are people in this world that can't even accomplish that in person, and he was able to do it through a telephone. The man he is now is not the boy that made the tragic decision. We ask the court to let Justin come home to allow us to be a family again. No matter the outcome, we will continue to be there for Justin and love him for the man he is today. But if he continues to stay in prison, it is not just him that is being punished. After 23 years in prison, he has missed out on so much, and so has our family. Mom's getting closer to retirement, and I feel she should have time with her son that doesn't include sitting in a room for a few hours with others watching. It should be going out to meals, spending holidays as a family, and just enjoying the small things that life has to offer. Heather and I both have children, and we see someone who can guide and support our kids to not make the same mistakes. A brother and an uncle who can relate to all of us on a level that I'm sure others can't understand. Someone who might be able to help a child who is not able to understand how to manage their feelings and to be able to provide guidance. We all have put in time to heal and grow, but it's impossible to truly move on if we can continue to have to go through the prison system to spend time with or talk to Justin. We're ready for him to come home now. He has a full support system ready and willing to be there for him, and we ask the court to let us truly put this behind us as a family. Thank you.
All right, the record should also reflect that I did read and review all the individual letters that were attached to the pleadings. You read them as well, as part of it, correct?
Yes,
Yes.
thank you.
All right, thank you. All right, so Ms. Brugman, anything else on behalf of the people?
No, Your Honor, a difficult case, and let's leave it in your discussion.
Thank you. Ms. Hennigan, anything else you wanted to add in response, add with regard to what you would like to say on behalf of your client, and then I'll give him an opportunity to speak. Do we want to take a?
No, we're good. We're gonna do this.
Okay.
I agree with Ms. Brugman. To date, this has been the most difficult case I've dealt with. We want to thank Justin's family as the victims of this crime, that they have been able to speak what they need to say as victims, but also acknowledge who he has become. So today, Your Honor, we're asking that the court and the community take a page from their book of forgiveness, and consider their willingness and capacity to heal as a family. Aside from that, Your Honor, despite the difficultness of this case, Justin made my job easy. He did all the work, the counseling, setbacks, the growth, more setbacks, the accountability, the programming, the growth, more setbacks, the relationship building. Justin did that. Not me, Justin. My job is simply to show this court the work that Justin did. Justin is a true example of what happens when an individual is bound and determined to use every resource they have to better themselves. Justin is proof that even an imperfect system full of imperfect individuals can work to benefit our imperfect world. Today, Your Honor, we humbly request that after consideration of court rulings in Stovall and Miller, consideration of the Miller factors, the acknowledgement of Justin's path to accountability and rehabilitation, that this court in its wisdom will find that there's a substantial and compelling reason for a downward deviation from the minimum guidelines that were previously determined to be 270 to 450 months. And we ask that you sentence Justin to a term of years not to exceed 279 months and grant his immediate release. Thank you.
All right, so Mr. Gibson, you stand at the podium next to your attorney. there anything you'd like to say on your own behalf before the court passes?
Yes, ma'am. I think about grandma every day. The decision I made to take her life, to take her away from everyone, all the pain, the heartache, the emotional trauma I have inflicted on so many. Grandma loved unconditionally. She loved, cared, and fought for me. I'm so ashamed that I took her love away from others. I am ashamed that I was loved. I did not know how to love for what it was. The impact of taking grandma's life was devastating. I think of grandpa losing the love of his life. The time they shared together bonded with love and family and friends, then betrayed by me. His world upended, his love gone. The emotional and mental trauma I have caused, the loss, the sadness, the void I created in his life. Aunt Connie and Uncle Steve, Mom, the pain they have felt from losing their mother, the love and nurturing now gone, the anger, the tears wept. I am the cause of unimaginable heartbreak. I'm bothered by the knowing I have caused so much pain in so many family, friends, and neighbors. Amber, Hannah, Charlie, and Luke, my cousins. My grandma will not see how you have grown. I took away the opportunity to create so many happy memories with her. I wish I could give you mine. I took away so much. My sisters, Heather, Betty, Elizabeth. The reach of the pain I have caused has traveled farther than I can ever imagine. Family, friends, neighbors, the community, the officers and prosecutors who have worked on this case. I'm ashamed of what I have done. I'm ashamed of the negative impact I have had on so many. I would not be here today if not for forgiveness. It has been the forgiveness of my mom and sisters that have taught me to forgive myself. I hated myself for so long, yet they continue to love me. It has been their mental and emotional support that has helped me develop to who I am today. While living with my grandparents, I felt alone. My father had just kicked me out. Uncle Steve would not speak or look at me, and Aunt Connie did not want me around. I began isolating myself whenever they came to the house. I would go outside and hide until they left. I felt unwanted and that I did not belong. It was these feelings that drove me to want to run away. I know now how wrong I was about the events of me being moved around. I know now how emotionally inept I was, sadness and depression without the ability to identify those feelings or a healthy way of coping or expressing them. I learned early in life to suppress emotions. When being punished by my stepfather, the more I cried or struggled, the longer or more severe the punishment became. I became conditioned not to struggle and not to cry. I became emotionless, numb. The only emotion I expressed was anger, all in unhealthy ways. While sitting in my cell at Marie Spear campus, I was crying. I asked by a staff member why I was crying. I told him because I had killed my grandma. He told me I was only crying because I got caught. This just reaffirmed my distorted thinking that showing emotions is bad. Sadness is a feeling to be suppressed. I then spent a little over a decade in prison, self-medicating to avoid shame, sadness, and depression. I finally reached my bottom in 2010. At that time, I was back in level 4, drinking heavily and taking prescription medication. Much of 2010 to 2012 is a blur. Except for when I began to question myself. What is it I want in life? What am I doing? How am I going to get there? I would call and talk to Grandma Mary twice a month. Then one day I was told she was being placed in hospice. I called again and was able to talk to her one last time. Her husband said she woke up and I was able to talk to her. The next day she passed away. I broke. It was as if all the sadness in me was spilling out. I cried drunkenly for most of the night. When I got up the next morning and looked at myself, I knew that I needed to make a change. I was not sure of what, but I could not continue with the same habits, same friends, and expect my life to change. In my moment of grief, I had another sobering realization. All that sadness and pain I felt, I'm the cause of those same feelings and so many others. Never again do I want to be the reason people feel those emotions. In early 2013, I was moved to Kinross. Here I was tapped to help the NLA and Natalie develop a self-help program for lifers to better prepare us for the parole board. Honestly, I knew nothing, little. I was more a student giving feedback. Amazingly for me, it was this program and being part of facilitating that was more therapy for me. The emotional development has been the most instrumental. Without the personal enrichment and parole readiness program, I don't know where I would be. I was able to truly find happiness. That despite being incarcerated, I was happy. I was allowed to be happy. I discovered that the one true control I have is over myself. So I concentrate on me, what I do to control my feelings and how I respond to them. I treat everyone with respect and dignity because it is right, and that is how I want to be treated. I'm not infallible. I spent so long with the belief I could earn a parole, and that belief had yet to be challenged. On my 20-year life of review, I was told I could not earn a parole. That was difficult to process. Then COVID hit the compound. I watched as friends and peers became devastatingly ill, being taken away in ambulances, some passing away. It was a very helpless time with loss and grief. I fell back to my old coping mechanism, drinking. The significant difference was I knew I was grieving. I knew I was self-medicating. Hope found, hope lost, happiness found, happiness lost. It was an experience I needed. Life will not always be full of joy and happiness. Without having gone through that loss of hope and loss of happiness, I would not have discovered I am capable and in control of how I respond to my feelings. I found that I have family and friends that I can share my struggles with. I had discovered it's more productive to talk about negative feelings rather than dwell and languish in them. With sobriety comes clarity. I share this newfound sobriety with Jacqueline, who I talk to often. We both are in this place that the desire to drink is not there, although I know that if the desire does come, I have family and friends to talk to. I give power to my emotions, and I choose to give power to the love and happiness. With love and happiness, that brings me to mom and my sisters. I have watched my sisters as they have grown to become beautiful, independent women you are today. With two nieces, Alexis and Ziva, two nephews, Carter and Wyatt, with one on the way. Our relationships have grown stronger over the years, and I'm truly a lucky brother and look forward to the future as an active uncle. Mom, I saved to talk about you for last. Without you, none of this would be possible. You have experienced so much heartache that I am directly responsible for. Through it all, you continue to love me, even when I did not love myself. I felt undeserving of love, still you did not give up on me. It was your unconditional love and forgiveness that has shown me how to love and forgive myself. The future is unwritten. The one thing that has remained constant is that how I treat and interact with others. Everyone is entitled to dignity and respect. I know I am not alone in this journey, and I'm excited about what the future holds. And I thank you for the opportunity, and I thank my family for being here today.
Ms. Hennigan or Ms. Bregman, anything further?
Your Honor, I would just note that the individual that Justin spoke of, Jacqueline, who has supported him in learning how to cope with sobriety, it's very important today, supporting him as well, and intends to be a constant in his life. Okay.
And Ms. Bregman, as always, you both always write wonderful briefs, but I probably will repeat a lot of your brief just because I like the format And so I will use part of that as the process I go through, because this does require a lot of important things to be placed on the record. And so what was the original sentencing date on this, Mr. Moore?
Was
October 27th.
No, December.
December
December
27th of 2000.
2000?
That's correct. December 27, 2000.
All right. So defendant was charged with multiple counts in 2000. Homicide, open murder, count 2, assault with intent, robbery armed, count 3, carrying with unlawful intent, count 4, felony firearm, and count 5, homicide, murder, second degree, which I assume was added for the purposes of a plea at that time. The other counts were dismissed, and on December 27th of 2000, he was sentenced to life with the possibility of parole. On July 28th of 2022, the Michigan Supreme Court in People v. Stovall 510 Mich. 301 held in part that a defendant's life sentence with the possibility of parole for second-degree murder imposed for a crime committed when he was a juvenile, violated Article 1, 16, Section 16 of the Michigan Constitution, prohibiting cruel or unusual punishment. The court vacated defendant's sentence in that case and remanded to the circuit court for resentencing. And that's why we are here today. Defendant, at the age of 15, deliberately planned to kill both his grandmother and grandfather, Betty and Richard Myers. He resided with his grandparents, who had cared for him on and off throughout his life. The original PSI, dated December 26 of 2000, detailed the voluntary account from the defendant after being taken into custody. The court does note he was 15 at that time. On June 30th, while both of his grandparents were out of the house, he had dug a hole in the backyard of his home with his grandfather's backhoe, practiced shooting the .22 caliber rifle. When his grandmother returned home, he shot her, then dragged her and put her in the bucket of the backhoe, making sure to lift it up to hide her from view. He left. He went with a friend to the mall. He returned home, took the gun outside, and lied in wait for his grandfather to return. He did not, even though he had planned to shoot his grandfather at that time. The rest of the day, he hid in different areas on the property, waiting for the police to arrive. He saw his grandfather and heard his grandfather find his grandmother's body. He admitted to taking money, an ATM card, credit card, and a key from his grandmother's purse. At the time, at the age of 15, he stated the reason he wanted to kill his grandparents was because they lectured him. It's almost 25 years later, we do recognize he was at the age of 15 at the time, and those statements were made. His grandfather, Richard Myers, did speak at the original sentencing, and that is included in a transcript as well as part of Ms. Bregman's pleadings and acknowledged by Ms. Hennigan in her pleadings. The rest of his family is here today with the benefit of 20 years or more passing since that time, and I'm sure that they have moved through stages of grief, anger, loss, and it appears they have now reached a stage of forgiveness. Unfortunately, his grandfather is no longer alive, so I don't know what he would have said if he had appeared today. He may have reached a stage of forgiveness, he may not have. But the court does take into consideration the statement he made at that time. It's clear that at that time, Mr. Myers had suffered a severe and intense psychological harm. The defendant is entitled to resentencing today under the rationale of Stovall, which held that a sentence of parolable life imprisonment for a juvenile convicted of second-degree murder is unusually excessive and violates the cruel or unusual punishment which is prohibited by the Michigan Constitution. In coming to this conclusion, the Stovall court rationalized that a life sentence with possibility of parole imposed on a defendant who is a juvenile at the time of the offense for second-degree murder, as in this case, violated the Michigan's Constitution, its prohibition on cruel or unusual punishment, and that sentence was the most severe possible penalty for second-degree murder, more severe than a 25 to 40 minimum sentence imposed on juveniles who commit first-degree murder. At the same time as Stovall, the Michigan Supreme Court also decided People v. Boykin 510 Mich. 171. That is a Michigan 2002 case, 22 case. Boykin dealt with a first-degree murder case, but the case discussed the sentencing court's obligation when sentencing a youthful offender to a term of years. The Boykin court held sentencing courts must consider youth as a mitigating factor at sentencing hearings conducted under MCL 769.25 or MCL 769.25A when the defendant is sentenced to a term of years. However, the court's consideration of youth need not be articulated on the record. Therefore, the Court of Appeals was correct when it held that there is no constitutional mandate to make specific findings on the record as to the Miller factors, but that sentencing courts should be guided by the Snow factors, which necessarily include consideration of youth as a mitigating factor. Lines 323 Mich. Abbott 352. People v. Boykin 510 Mich. at 196. Although the defendant in this case addresses the Miller factors in his mitigation and resentencing memo, MCL 769.25 and 769.25A only apply to cases in which the prosecutor seeks a life without parole sentence, which is not the case here. That said, and I agree with Ms. Bregman on this, there have been few cases interpreting Stovall, and it is unclear at this time if the reviewing courts will require the trial court to also consider the Miller factors in second-degree murder cases. This very concern was raised by Justice Boonstra in his concurring opinion in the unpublished case People versus Abatoy, issued August 18th of 2022. The Supreme Court in Boykin stated that sentencing juvenile defendants who were convicted of first-degree murder is an exceptionally daunting task for trial courts. I would further add, sentencing any juvenile or adult offense is daunting. Post-Boykin, the task is even more exceptionally daunting as trial courts will be obliged to grapple with Boykin's self-contradictory descriptions of what trial courts are and are not obliged to do. Out of abundance of precaution, I will, as Ms. Bruggeman recommends, even though it's not required anywhere in case law or statute, today this court will address on the record not only the Snow factors, but the Miller factors and the mitigating factor of youth in general when I fashion this sentence. Sentences imposed are to be proportionate to the seriousness of the circumstances surrounding the offense and the offender. People v. Milborn 435 Mich. 30. Because the Supreme Court has held that youth, a circumstance of the offender, matters at sentencing, youth does affect the court's interpretation of the Snow factors. In Snow, the Michigan Supreme Court directed a sentencing court to consider the following objectives: the reformation of the offender, the protection of society, the disciplining of the wrongdoer, the deterrence of others from committing like offenses. Snow 386 Mich. at 592. In Boykin, the Supreme Court explained how youth affects a sentencing court's consideration of the Snow factors. Thus, when deciding the minimum term range for a defendant's term of year sentence, the court is required to consider the Snow objectives and the mitigating factors of the defendant's youth at the time of the offense. As noted by both counsel under the Snow factors, the defendant's attorney at the time, I'm trying to figure out, was either John Glazier, but then Donald Callahan?
That was the sentencing or appellate.
Oh, okay.
I believe it was Mr. Baker.
Oh, John Baker.
Mr. Glazier was his attorney. Mr. Baker appeared on his behalf at sentencing.
Okay. He did address the defendant's youthfulness at the time of sentencing. Taking into account the mitigating factor of youth, the prosecutor has recommended and stated correctly that it's necessary to also look at his institutional record when looking at the defendant's character and potential for rehabilitation, disciplining of the wrongdoer, as well as concerns for the protection of society and deterrence. According to the misconduct summary report attached to the updated pre-sentence report, he has had, his most recent misconduct was July 26th of 2022. According to the updated PSI and verified by his prison record, he has committed at least 22 misconducts while incarcerated over the past 23 years. I agree that this is not an astronomical number in the prison world. And a third of them have appeared in the last few years, but Ms. Hennigan, as well as Mr. Gibson, has addressed both his mindset and the factors that contributed to what he believes caused him to commit those misconducts. Defendant has been reviewed by the parole board 3 times, 2010, 2015, and 2020, with the majority of the members voting no interest each time. I believe his next review will be July 1 of 2025. He hasn't as of yet received a public hearing, and he was denied commutation or pardon from the governor back in 2008. He has received his GED. He has engaged in various positive programming, and it appears everything that he was capable of being involved in, he has been involved in. Most notably working on reentry programs as well as dog training. He has developed as an adult substance abuse problem in the Michigan Department of Corrections, and many of those misconducts seem to be related to that. He does accept responsibility and express remorse. It's evident from his statement today, also the description of his family's interactions with him over the last 20+ years. And while the prosecutor makes special note of the fact that his description of the events has changed from what he said over 20 years ago, I don't think that is entirely unusual when time passes. I see victims and defendants' stories change over time, maturity, age, life experiences, lack of memory, changes in memory can contribute to that. The defendant definitely did express remorse today, and in fact, cried. So I do acknowledge that his statement at the time of the offense at the age of 15 to the police officers in the probation department is somewhat different than his description given both through counseling and to the parole board. I contributed most of that to time passing and maturity. I agree with the prosecutor that while we don't know if we have to address the Miller factors because this is so new, I agree that it is important that we do so when fashioning this offense. The Miller mitigating factors are as follows: his chronological age and its hallmark features, among them immaturity, impetuosity, and failure to appreciate risks and consequences, to the family home and environment that surrounded him and surrounds him, from which he cannot usually extricate himself, no matter how brutal or dysfunctional. The circumstance, number 3, the circumstances of the homicide offense, including the extent of his participation in the conduct and the way familial or peer pressures may have affected him. Number 4, whether he might have been charged with and convicted of a lesser offense if not for incompetencies associated with youth. For example, his inability to deal with police officers or prosecutors, including on a plea agreement, or his incapacity to assist his own attorneys. And 5, the possibility of rehabilitation. People v. Skinner, 502 Michigan, citing Miller 567 U.S. at 477, 478. Addressing number 1, his chronological age and its hallmark features, among them immaturity, impetuosity, and failure to appreciate risks and consequences. There is no doubt that the defendant was young when he murdered his grandmother. The prosecutor argues that he was not naive to the criminal justice system, as he had already racked up adjudications for retail fraud, third, unlawful driving away of an automotive vehicle, domestic violence, larceny less than 200, unarmed robbery, and another UDAA. Defendant at that time clearly had an issue with authority and impulsivity and failed to take into consideration the gravity of his actions. However, as indicated before or and above in the prosecutor's statement, defendant continued to commit misconducts in prison, demonstrating that he does not have control over his impulsive behaviors. Psychology, therapy, counseling studies now show that the male, well, I guess I shouldn't say just men, but the teen brain continues to develop until the late 20s. One of the things that continues to develop is the prefrontal cortex, which is one of the last things that mature or finish growing in young adulthood. It's clear that mental illness was present. There was some discussion today between his family, himself, Ms. Hennigan, anxiety, depression, abuse and neglect, not in his grandparents' home, but in his prior home, based on statements made about his stepfather, as well as neglect by his biological father. So the court does find that impulsivity at that age, along with an issue with authority, would be common and not out of the ordinary. The ability to look at and take into account the end result or the gravity of his actions also is not uncommon at that age. But I do not find the level of misconduct that he had in prison to be out of the ordinary or excessive. Number two, the family and home environment that surrounds him and from which he cannot usually extricate himself, no matter how brutal or dysfunctional. Defendant did, in his statement, state that he had a very good relationship with his grandparents, but there is evidence, both by statements made by his family members and also himself, that his home life outside of his grandparents' home, there was psychological, physical abuse that was taking place. I mean, it's very clear not by his biological mother or his mother, but by his stepfather, and lack of by his biological father. His grandparents provided a safe, loving home for him because his mother was working, trying to support the family, but his behavior is based on what came before that. So I do find that he was in an environment before his grandparents that did have abuse. Number three, the circumstances of the homicide offense, including the extent of his participation in the conduct and the way familial or peer pressures may have affected him. Defendant on his own accord did, without the help of anyone, plot to kill both of his grandparents. Nobody asked him to do it. No one helped him to do it. So I don't find that there was any peer pressure or family pressure to commit these offenses. He carried them out on his own. But I do find that the abuse and neglect he had been exposed to could have impacted, would have most likely impacted his behavior at this time, as well as his prior juvenile record. Number four, whether he might have been charged with and convicted of a lesser offense, if not the incompetencies associated with youth. The court agrees that there is no evidence from the record that one, he would have been charged with a lesser offense because he was charged with homicide over murder and he pled to a lesser offense. But the court also finds that there's no evidence that he was unable to participate in discussions with his attorney or didn't understand the proceedings in any way. Number five, the possibility of rehabilitation. Parties all agree that he has completed programming available to him successfully. And while that does not mean that he has been fully rehabilitated, it does mean that he has made an effort to better himself. Today, as well as in his statements to family as expressed by that family today, he has expressed remorse for what he did. And he also did acknowledge that there was abuse with his father and his stepfather, and his upbringing with them, he believes, turned him into the 15-year-old child that would do this. He did have a psychological evaluation in 2020. And the psychologist at that time stated he doesn't appear to present with empathy or regret. He shows no emotion when answering the questions and stated his answers in a matter-of-fact way. When asked about his grandfather, he said he wrote him a letter years ago and he gave it to his mom, but his grandfather would take it, and then he died. A 15-year-old child to the man he is today, a lot of time has passed. He has dealt with it. He's had to tell this story over and over when dealing with counselors and psychologists and parole boards. And I don't find that this is enough to determine that he has not taken advantage of rehabilitation available to him. The defendant in this case is asking for immediate release. The prosecutor, finds this inappropriate when you take into account the above factors, the gravity of this crime, and the psychological evaluation. He has struggled intermittently with substance abuse. And I know it exists, but I'm a little taken aback when you hear about people struggling with substance abuse in the Michigan Department of Corrections, but it exists. It's not allowed. We know alcohol and substance abuse is not allowed in the Michigan Department of Corrections, but we do know where there's a will, there's a way. So, determining the appropriate sentence in this case, the court has considered the seriousness of the offense, the history, the principle of proportionality, the statutory penalty, the cost of confinement, the sentencing guidelines, the report and recommendation of the probation department, as well as what has been set upon the record at this hearing. The criteria and the reasons for the sentence are the nature and gravity of the offenses, the offense, the discipline appropriate to its commission, deterrence against repetition by you and by others, the potential for reformation, vindication for the law and the protection of society. The recommendation in the updated report is for the defendant to serve 450 to 720 months. Is served at this point. We served about served 8,382 days at this point, which is about 279 months. That's about right. The recommendation, as I said, by both the prosecutor and the public or probation department is for a sentence of 450 months to 720 months. This court, while I do not agree that sentencing under the guidelines would be appropriate in this case, based on the nature and the gravity of this offense, I do feel that Mr. Gibson, under those mitigating factors, has made progress and worked hard. He has the support of his family. He has maintained connections with them. At the time he does get released, he will have those support in place as he continues his life. So, the sentence of the court that you will serve 290 months to 290 months to 720 months with the Michigan Department of Corrections. I do this because you have made efforts. You have gained the forgiveness of your family. I believe you have a support system in place, but I also can tell you it's not going to be an easy transition. You have spent the formative years of your life in the Michigan Department of Corrections. I do believe that they have worked hard to provide services as allowed and provided with funding from the state of Michigan to you, but it is a process. It still doesn't mean the parole board is going to release you. I have no control or authority over that. So, I will give you credit for 8,382 days served.
Judge, I apologize. You had 178 already credit in December of 2000.
I'm hoping the 8,382 days would be part of that, Mr. Moore?
Correct. That was added on February 22nd of 23. He served 22 years, 7 months, 11 days. And I added on the days from there and came up with the 8,382 days. Time computation will correct if there's any issues with that, but it should be accurate.
Is that good, Miss Adams?
Okay, thank you.
You're welcome. All right, there's still $130 crimes victim rights fee, $68 in state costs, $60 DNA fee. I'm assuming that's already been paid. No, I don't know. So I do have to order that. That could be a condition of parole at any time you get parole, but I think you're working at the prison. So I need to take it out of that. I probably already did that. Anything else, Mr. Moore?
No, Your Honor. If back when he was sentenced in 2000, there was no DNA fee, so I don't know if we need to add that now or not.
No, I guess we strike that, no DNA fee.
Okay.
Mr. Gibson and Mr. Gibson's family, I will tell you, but for you appearing today and your statements today and the fact that you will provide support for him and also your statements today, I probably would have sentenced you to the recommendation. Because most of the time there are people showing up in the courtroom. This is a difficult case. I appreciate everybody's hard work on it. Do we have appellate paperwork, Ms. Adams?
I believe it was in the file, Judge.
All right, so my bailiff's gonna hand down to your notice of right to appellate review. I'm gonna ask that you initial and date the first copy, just acknowledge you received the paperwork. That's gonna go in my file. The other copies are for you. If you wish to appeal your sentence, you can fill out the information on the form and mail it to the court within 42 days of the address listed on the form. Gibson, I do wish you the best of luck, and the record should reflect I received back a signed copy of the notice of right to appellate review. Thank you. And Ms. Bergman and Ms. Hennigan, if I can have 5 minutes of your time. 2 minutes, maybe.
You want us to go in the back?
No, they can take them. You can take them. Then we'll wait till he goes through. Mr. Glazier is not connected. Ms. Iddings and Ms. Well, Mr. Noe is not here. It'll just be a few minutes.
He's out talking to the client.
I'll grab those, Judge. If you need anything.
We'll go this way. We're gonna take a break. Okay, thank you. It's not a couple more sentences. but-
Oh, Judge,
Yes.
I wanted to show you my assistant.
Well, it looks like you finally got a competent assistant. Is that your,
This is Bodie. He's my number 3 grandchild. Say hi to the
he's
judge.
beautiful.
Oh, thank you. She
All
sees
right, I'll be right
him.
back.
All right, no hurry. There you go.
Oh, it's so
This
good
is
to
Heidi.
see you.
Good Heidi.
So good to see you. Oh, I'm so glad. Yeah, I get to- Joe. So strange. Oh, especially now. Yeah, yeah. No, I don't blame you. I just feel so.
She's great to watch.
Yes, she is so good. I cried. Yes. You have no idea what she did. Yeah, is that one where you thinking about one maybe nobody that told you. It's called. I'm so proud.
What? We got to go.
I love it. I'm sorry. And but I come to circle like. Yes. Yes. I know. Thank you. It's so wonderful to see you.
Good to see
Thank
you.
you.
I'll see you,
Tell the
I'll
judge-
see you in a half an hour.
Yeah, please tell Judge I said hi, okay?
I certainly
Okay,
will.
Thank you. Oh, bye.
Yeah, 2 bags downstairs. Okay. You can just say that, you know.
I'm telling you, that's all I just did. Please, Chris.
That would be good. Are you Colleen?
Yes,
I'm John. I'm filling in for Mike today.
okay,
Did you have a chance to read the pre-sentence investigation?
no,
All right. Well, they'll probably make you read it unless you want to waive it. What they're recommending is 3 years probation, with a year in jail, but to be released to a inpatient program, you got to do drug court probation.
right.
John, do you want to be put in a breakout room with her while we're waiting?
No, I'm all right.
Okay.
Okay, you okay with that? Or do you want to talk to me? Private.
Yeah,
Okay, all right.
I wouldn't do the year in jail though, right?
No, well, you're gonna be released to a drug program, inpatient drug program.
Okay, I mean, that'd be like, I've been here 4 months already.
Yeah, we'll check with the probation officer when she gets here.
Okay,
I don't think it usually takes very long.
okay.
The whole point, that's what I was trying to tell them, important that they wanted it on, trying to take it off, of course, they know, I'm gonna have it on, I paid for it, I don't understand. So now I'm sitting here, and I was wondering if the building, I called out, I doubt it, but I called out. Do you have another call, guys?
So I guess we don't really need to do the breakout room, but so what they're saying is for that year, if I screw up, I have to do the remainder of the year.
Yeah, I think we'll discuss that, but we'll talk with Miss Teskey when she gets on here. She give you
John,
some.
I'm on here.
Oh, how long does it take? Usually, is it going to take to get her into an inpatient program? Do you know?
Probably 3 weeks.
3 weeks. All right.
Yeah.
So what we'll do is, if you're not in that program in about a month, send a letter and make sure you get a hold of me. Send a kite or something that we need to get a hold of you. Okay.
Okay.
That's our office. Mike, you would let Mike know.
Okay.
All rise.
All right, Mr. Glazier. Okay, and Ms. Barrett, can you hear me?
Yes.
All right, this is in the matter of the people of the state of Michigan versus Colleen Marie Barrage, file number 2023-21451FH. I have John Glazier appearing on behalf of Ms. Barrage and Ms. Barrage appearing via Zoom from the Illinois County Jail. So, Mr. Glazier, you received a copy of the pre-sentence report.
I have, Your Honor.
Ms. Barrage, have you had an opportunity to read and review the pre-sentence report?
No.
Oh. Mr. Glazier, have you met with her to review the PSI?
No, this is Mike's case, but I reviewed it this morning and I've talked with her. And I think we have enough information that she would want to proceed without having read it. Is that correct, Ms. Barrage?
Yes.
Okay, so you believe that Mr. Glazier read through it with you?
Yeah.
And are you satisfied with Mr. Glazier as your attorney today and the advice that he gave you?
Yes.
And you've had an opportunity to ask him any questions or have any discussions you needed?
Yeah.
Okay. Mr. Glazier, do you wish to explain or challenge the accuracy or relevancy of any information in the pre-sentence report?
No, Your Honor.
All right. Before, let's see, does the pre-sentence report disclose any prior convictions in which there exists any known constitutional defect?
It does not, Your Honor.
I have the probation guidelines in this case to be 0 to 17 months. Do you agree with that computation guidelines?
I do, Your Honor.
All right. Before the court passes sentence, is there anything you'd like to say on behalf of Ms. Barrage?
Yes, Your Honor. I know Ms. Barrage wants to get into drug court and get off the drugs. She knows she needs to do that, and she's wants to assure the court that she'll make her best efforts and hopefully succeed in that. The recommendation here is for a year in jail, but to release her early to an inpatient program. We've talked with Ms. Teskey just a few minutes ago. She thought that would take about 3 weeks. My biggest fear is always that somebody sits there for a year and we don't know that they didn't get into the drug program. I've advised her to get a hold of Mike, send him a kite or whatever she needs to do. If she isn't into that drug program, I would say by the by November 21st or something along those lines. And she said she would do that. Is that correct, Ms. Barrage?
Yes.
All right. So we hope you get into that program, do the inpatient program, get out and, successfully complete drug court and everything will be fine for you. Do you understand that?
Yes.
All right. But if for some reason you're still sitting there on November 21st, have them get a hold of us somehow. Get a hold of Mike. All right. Thank you, Your Honor.
And I would say that Ms. Teskey is very good about following up, like you can't find placement, she'll follow up. So, all right, Ms. Barrage, is there anything you'd like to say on your own behalf?
No.
All right. And, well, I guess all right, in determining the appropriate sentence in this case, the court has considered the seriousness of the offense, your history, the principle of proportionality, the statutory penalty, the cost of confinement, the sentencing guidelines, the report and recommendation of the probation department, as well as what has been said upon the record at this hearing. The criteria and reasons for the sentence are the nature and gravity of the offense, the discipline appropriate to its commission, deterrence against repetition by you and by others, the potential for reformation, vindication for the law, and the protection of society. It's sent to the court that you will be placed on probation for a period of 3 years. During that term of probation, you must not use or possess alcohol, use or possess any controlled substances, and for the purposes of adult drug treatment court, that does include marijuana. Do you understand that?
Yes.
All right. Cannot possess any paraphernalia. You must enter and complete any outpatient or residential treatment that you are referred to. So when a bed is obtained and you go to that program, if you leave or you get kicked out, that would be a violation of probation. Do you understand that?
Yes.
Okay. You must take all medication as prescribed and understand that you must submit to search and seizure of your home, your property, your vehicle, your computer, if the agent has reasonable cause to believe that you have items which violate the conditions of your probation. They have access to your home if they need it. You must maintain employment of up to 30 hours per week, and we have lists and lists of jobs to help you do that. Sentence of the court is 1 year in jail with credit for 109 days already served, but you may be released to an outpatient or an inpatient program. And usually it just takes a couple weeks. So that should happen pretty quick. There is a crime victim assessment fee in the amount of $130, a $30 per month supervision fee without tether, $60 if you're required to wear a tether, $750 in court costs, $450 in attorney fees, $68 in state costs. You must attend, comply with, and complete the Lenawee County Adult Drug Treatment Court, following all recommendations made. Ms. Teskey, anything else?
No, Your Honor, I think you covered everything.
Thank you. So Ms. Barrage, welcome to the Adult Drug Treatment Court. It's a pretty intensive program. The purpose of it is to provide wraparound services for you to help you through the process. So you have to be ready to fully embrace that. And inpatient rehab will put you in a better mindset for coming into the program. You do have a right to appeal the sentence. We will provide to you at the jail 3 copies of your notice of right to appellate review. I need you to initial and date 1 copy for our records, the other 2 are for you. If you wish to appeal your sentence, you would fill out the information on the form and mail it to the address listed on the form within 42 days. All right?
Okay.
All right. So I wish you the best of luck. Okay?
Thank you.
Thank you. All right. And I believe that concludes our criminal docket today.
Yeah, that's all I have, Your Honor. I just wanted to warn you, you got a Spartan fan sitting on your bench in front of you.
So, Mr. Glazier,
Yeah.
this is unusual because Mr. Noe and I are both state grads.
That's up.
And then I also have the intimidating Miss Adrienne Iddings, who's a vicious U of M fan here. So, yeah.
Good
Oh, and then
thing.
we have Miss McGrain, who, if you say you went to any other law school than U of M, she gives you this little look.
I'm glad I did this by Zoom rather than get attacked by 3 people when I went in the courtroom.
So I will say that, you know, I always hope state wins, but U of M does have a better team this year, unfortunately. So.
Yeah, state always plays them tough. It doesn't matter how bad a team they got. It's always a tough game.
Right. All right. All right, go green.